Good afternoon and welcome. I want to thank all of you for joining us today as the NYU School of Law community pays tribute to the Honorable Jack Weinstein. Each year, the NYU Annual Survey of American Law dedicates its forthcoming issue to an individual who has made a significant contribution to the legal field. We've had the privilege of honoring distinguished judges, including Supreme Court Justices Scalia and Breyer, Court of Appeals judges Posner, Wood, and Wald, among others, as well as leading academics, including Arthur Miller, Anthony Amsterdam, and the late Derek Bell and Ronald Dworkin. And we could not be more pleased that our students on the NYU Annual Survey of American Law have chosen to dedicate their 72nd volume to the Honorable Jack Weinstein, United States District Court Judge for the Eastern District of New York. I'm delighted that the annual survey has chosen to recognize his massive accomplishments, and in doing so, that they have brought together such a remarkable group of friends, family, and colleagues to celebrate his extraordinary career. I especially want to welcome Judge Weinstein's family members, Susan Burke and Ronnie and Andy Rosenberg. We're delighted that you're here with us today. The legal community has been profoundly influenced by Judge Weinstein's decisions, his teaching, his scholarship, and his leadership over many decades. This is clear to everyone who is here tonight, including former students and clerks, academic collaborators, and colleagues from the bench. He began his storied career by earning his BA from Brooklyn College in 1943. He then served as U.S. Navy lieutenant before earning his law degree from Columbia in 1948. Soon after graduation, he joined the Columbia faculty as a lecturer before going on to clerk for Judge Fuld of the New York Court of Appeals. He would later return to Columbia as a faculty member at the school, where he taught full-time until joining the U.S. District Court for the Eastern District of New York after having been nominated by President Johnson. He was chief judge from 1980 to 88 and assumed senior status, mocking the title, in 1993. During his time on the bench, he's also served as an adjunct professor at both Columbia Law School and Brooklyn Law School and has taught countless students, hugely influencing their education, their careers, indeed their lives. Judge Weinstein is one of the longest-serving members in the history of the federal bench. Throughout his 5 decades of service, he's become well-known across the country for the strength of his principles and his unflagging efforts to combat what he calls the unnecessary cruelty of the law. He's gone to great lengths to protect and promote that concept of justice, like for a time refusing to handle drug cases out of opposition to mandatory minimums and issuing a series of rulings that attacked the mandatory 5-year prison sentence for defendants charged with receiving child pornography. As the bench's boldest overseer of mass tort litigation, he has presided over thousands of cases and has set many of the country's most important mass tort precedents. In the 1980s, he brought together thousands of claims against the government by Agent Orange victims into one case, and later brokered a $180 million settlement, which set the stage for nearly every large class action lawsuit since in the mass torts area. He has called on Congress to expand Social Security into a national health insurance and comprehensive disability plan, and to create a federal court for helping victims of mass disasters, from train crashes to terrorist attacks. Throughout his career, he has made numerous innovative contributions to the field of class action and aggregate litigation, while showing a resolve to interpret law in a way that prioritizes the public over private interest. It is therefore only fitting that our students decided to make his work the centerpiece of their newest volume. I'd now like to turn the program over to this year's editor-in-chief of the annual survey, Christina Liu, class of 2015. Christina earned her BA in biology and neuroscience from Williams College. She worked as a paralegal for the Justice Department's Environmental Crimes section before joining us here at the law school. And while at NYU, she's worked as a research assistant to Professor Erin Murphy, has served as a student fellow for the Center on the Administration of Criminal Law, and after graduation, she plans to clerk first for Judge Gorton of the District of Massachusetts, and then for Judge Chin of the Second Circuit. The Journal has had another spectacular year under Christina's direction, so thank you, Christina, for your leadership and for all the hard work you've put into the effort this year. Christina.
Thank you, Dean Morrison. The dedication ceremony is a very important and very special event for the annual survey and for the law school, so I thank you for your support and involvement tonight. I'd also like to thank Tracy Knopfer and Paula Grady from Student Affairs, as well as all the student editors at the annual survey for their help in preparing for tonight's event. And I'd especially like to thank Michael Roberts, our symposium editor, who was the first to suggest Judge Weinstein as a candidate for our dedication. The NYU Annual Survey of American Law is this law school's second oldest legal journal. It was originally founded in 1942 as a vehicle for the NYU faculty to compile a comprehensive annual reference to developments in the field of American law. Today, it is a quarterly publication that continues to explore contemporary legal developments in this field from a practice-oriented perspective. As Dean Morrison said, each year, the journal dedicates its upcoming volume to a preeminent juror, legal practitioner, or legal scholar. To that end, the editors nominate and select an outstanding contributor to American law. We then honor the dedicatee at a ceremony held every spring at the law school, where we invite colleagues and friends to deliver tribute and celebrate the dedicatee's legal legacy. Tonight, we honor Judge Jack B. Weinstein for his many contributions to legal scholarship, legal practice, and jurisprudence. My role in this ceremony is to speak on behalf of the journal and to underscore the praiseworthy qualities that led to our decision to nominate him. Judge Weinstein, with so many respected and experienced practitioners, scholars, and a fellow judge speaking tonight, we wanted to explain your impact on us, on students. First, we thank you for your towering contributions to the legal scholarship of civil procedure, evidence, and complex litigation. You have written leading treatises and authoritative textbooks on all three subject areas and more. You have reformed the rules of civil procedure in the state of New York, and you have transformed the legal landscape of mass tort litigation and class actions. Today, law students across the country read and learn from the words of your case opinions, your case books, and your prolific law review articles. Second, we honor your work ethic and your unwavering commitment to justice, which inspire both the people who have actually met you and the people who have read and heard so much about you that they feel like they've met you too. You work hard. You graduated high school early, and you worked on a submarine in the Navy, which must have been difficult with the height of 6'2". You worked, when you came back, a full-time job on the Brooklyn docks, and you balanced that with night school at Brooklyn College. During your first week at Columbia Law School, you became a father, and shortly after your graduation, you were hired as a full-time professor at Columbia Law. Today, you've served as a judge for the Eastern District of New York, and you've done so for almost 50 years. You bring that boundless determination to the courthouse, where you strive to achieve a fair and just result, even when the task seems daunting or superficially impossible. You use creative procedural methods to deliver justice when it is otherwise unattainable, perhaps by creating a limited fund class action, using compensatory damages and a punitive multiplier, as in the Agent Orange litigation, or by declaring a multi-district litigation case a quasi-class action and modifying the contingency fees so that people harmed by antipsychotic medication would receive their fair share of the settlement proceeds. You also generously volunteered to help reduce the immense backlog of habeas corpus petitions in the Eastern District of New York by single-handedly taking on and deciding 500 petitions in less than a year. Third, we admire your warm personality and your humble demeanor. In the midst of developing groundbreaking insights and safeguarding justice in the courts, you still find the time and energy to reach out to the people around you, to colleagues, to friends, and to strangers through little acts of kindness, gestures that might not seem small to you, but that mean the world to the people receiving them. For example, one professor told me that when she was a very junior professor, She received a handwritten note from you, even though she had not yet met you. You wrote that you very much enjoyed reading one of her law review articles. She remembers that day as one of the happiest in her professional career, and that it served as further inspiration for her legal scholarship. A fellow journal member told me that when she was an intern, she visited your courtroom for a proceeding and was pleasantly surprised when you asked her for her name in her school afterwards. And she was even more surprised later when she returned to your courtroom and found that you still remembered her. And I've heard from many people that in your courtroom, you like wearing a suit rather than robes, and that you enjoy sitting with litigants at counsel table instead of at the bench. You do this, you say, because you want to make the courts more accessible to the people. Another professor told me that you've said you only wear your robes to formal induction ceremonies and when your mother is visiting your courtroom. That professor also received a note from you. He had organized a conference that you attended, and you wrote a personal handwritten note to him thanking him for the experience. While you have personally described yourself as just a tired old judge who has temporarily filled his quota of remorselessness, your colleagues, friends, and students would undoubtedly disagree. Your self-awareness, your self-deprecating humor, and your appreciation for your position not only make you an influential leader, but also an incredibly present individual. You have sat face-to-face with defendants, have placed a defendant's hand in yours as you sentenced him, and have put your arm around a defendant's family member to provide comfort in times of need. You are ever conscious that you are dealing with people and that you are just like them. Judge Weinstein, you have made tremendous contributions to our law school experience and to our personal development as students. Your scholarship, produced while you carried a full caseload, has challenged us to search for greater meaning in the law, to fall in love with the discipline, and to join the conversation. On top of all that, you still make time to personally thank or to recognize the accomplishments of the people around you, whether they are colleagues at a conference, professors at the start of their careers, or even student editors on law journals like ours. As we complete our studies and prepare to leave the law school nest, we will internalize the lessons that we have learned from your scholarship, your compassion, and your craft, so that we may embark on our own careers with clear eyes and full hearts. On behalf of the student editors at the Annual Survey of American Law, on behalf of the law students at NYU Law, and on behalf of all law students in every law school across the United States, we are so very honored to celebrate you and your legacy here tonight. Thank you for being with us.
It is a measure of Judge Weinstein's enormous impact on so many institutions that we could fill many stages with people prepared to comment on, indeed testify to, the enormous impact of the judge on their lives and their work. I think in particular of our own Arthur Miller, who collaborated wonderfully with the judge over many decades. And in that sense, the people speaking here this evening speak on behalf of dozens and dozens, indeed hundreds and hundreds of former clerks, of colleagues on the bench, of academic collaborators, of practitioners whose own work has been deeply affected by the thinking and the work of Judge Weinstein. So it's my job to introduce each one of them in turn, and we start with the Honorable John Gleeson of the Eastern District of New York. Judge Gleeson served as a member and chair of the Defender Services Committee of the Judicial Conference of the United States and has taught complex federal investigations and sentencing as a member of our adjunct faculty here at the law school since 1995. He previously worked as a litigation associate at Cravath, Swaine & Moore before becoming an assistant United States attorney in the Eastern District. He served there as chief of appeals, chief of special prosecutions, chief of organized crime, and chief of the criminal division until 1994 when he was appointed to the bench. And we are very pleased to have him with us here this evening. Judge Gleeson.
Thank you, Trevor. Thank you, Christina. I can't tell you how flattered I am to be included in this ceremony and to be on the stage with this elite group of speakers. It's true you're going to hear about Jack Weinstein's scholarship in jurisprudence, but not from me. And thinking about how I could be a value added to this ceremony, it occurred to me I'm the only one here who grew up as a trial lawyer in Jack Weinstein's courtroom. And then just when he started to think he was making a little progress with me as a trial lawyer, I grew up as a judge on his court, and he's still working on that. So as I say, you'll hear from these other speakers about the contributions that Jack Weinstein has made to our profession and really to our society, the reasons he's become the single most influential judge of our time, even while occupying the lowest rung on the Article III ladder. What I hope to contribute to our collective presentation are a few things about the great Weinstein that you just have to appear before him in court or be his colleague to learn. Before I became a judge, I was a prosecutor, as Trevor just mentioned, and through the sheer luck of the draw, I had a lot of cases in Judge Weinstein's courtroom. He's always very pleasant. Christina began to describe the atmosphere in his courtroom. He doesn't wear a robe. Actually, there was an exception to that rule. And if I keep digressing, they're never going to get to speak. But the exception to that rule was when we prosecuted Justice William Brennan for conducting the affairs of an enterprise, specifically the Supreme Court, Queens County, through a pattern of racketeering activity consisting of accepting bribes. And when Justice Brennan was on trial in Jack Weinstein's courtroom, he wore the robe. And someone asked him why. And he said he wanted the jury to be sure that they knew which judge in the courtroom was on trial. But typically he doesn't wear the robe, and he doesn't even sit up on the bench, as Christina mentioned. He sits down in this huge conference table in the well of the courtroom where conversations are had. It's very civilized, much more like a book group than a courtroom. The rules of engagement are different as well, which is something that takes some getting used to as a young lawyer. I learned this the hard way early in my career. It's the first appearance in a drug trafficking case. In every other courtroom, these appearances include pro forma pleas of not guilty, and they set another adjourn date. But things are different in Jack Weinstein's courtroom, and in this case, he asked the defense lawyer if he anticipated filing any motions. The defense lawyer said he was thinking about moving to suppress some statements, maybe moving to suppress the fruits of a consent search. We were all sitting around the table, and the judge pointed with his chin at the man sitting next to me and said, "Is this your case agent?" I said, "Yes." He said to the guy, "Raise your right hand," and he swore him in. Then he turned to me and said, "Go ahead." Now, I had this agent who was sitting there enjoying this Starbucks-like atmosphere in the well of the courtroom. All of a sudden, he's wide-eyed. He says, "What's going on? What's happening?" I said, "I'm not sure, but I think we're in the middle of a suppression hearing right now." Trials were always a delight in Judge Weinstein's courtroom. He knows a little bit about evidence, which is good for prosecutors. You know, in some courtrooms, you have to be careful what you ask for because you're probably going to get it. And then you could find yourself trying the case again after the appeal. Not so in Jack's courtroom. He's smart. He'll protect you from yourself if you're a prosecutor, and he can make a pretty good record. In one of my early trials before him, I offered into evidence a recorded statement made by an undercover agent a couple of minutes after the deal went down. For appearance's sake, when the agents came in and made the arrest, they arrested the undercover as well, so he couldn't turn off his body recorder. And he made a critical statement about which one of the defendants had passed the sample of the heroin. I offered that statement in evidence, and at sidebar, Judge Weinstein made an eloquent ruling, complete with case citations, even though it was an oral ruling, admitting the evidence, holding it fell within the present sense impression to the hearsay rule, present sense impression exception to the hearsay rule. So I head back to the podium, feeling pretty good about myself, and he summons us back to sidebar, and he says, and this is a quote, "Just in case those people up there can't understand that ruling, let me make another." Then he makes another equally eloquent ruling about the statement being an excited utterance. And I remember thinking, this guy makes a pretty good record, and given the way he baits the Court of Appeals judges, it's a good thing he makes a good record. Those rulings, of course, are no accident. Among his many accomplishments is Weinstein's federal evidence, the Bible of the law of evidence. As of a couple of weeks ago, that treatise had been cited 25 times in opinions by justices on the Supreme Court of the United States, more than 4,300 times in the published decisions of the lower courts. But I'm here to tell you this afternoon that not all of Weinstein's rules of evidence can be found in that treatise. For some of them, you just have to hang out in his courtroom for a while. Take, for example, the "you've got enough" rule of evidence preclusion, which I ran into more than once. Each time it was the same. I'd pose a question on direct. Sustained came a ruling from the bench. Being the lawyer that I am, I'd scurry up to sidebar. I'd say, "Judge, this is perfectly admissible evidence. It's quite probative. I don't understand why you said sustained, especially since nobody said objection." "You have enough evidence already. Let's finish up this trial." I start explaining why the evidence isn't cumulative, but he cuts me off. So I'm not saying it's cumulative. I know it's relevant, admissible, probative evidence. I'm just saying you have enough evidence to win your case, so we're going to end this trial. And he's got that big smile on his face. So I know it's okay to push back, and I say, "Judge, I'm glad you're persuaded, but you don't get a vote. I'll make you a deal. Ask the jurors if they've heard enough to convict. If they all raise their hand, I'll rest." He says no, excuses the witness, tells us to get ready to sum up. He sees I'm not too happy with this decision. And then he gets the last laugh. He points to the court reporter's machine, and he says to me, "Don't worry, you have your record for appeal." And as I say, he's got that smile on his face because he knows just what I'm thinking, which is the only way that record is ever going to be of any use to me is if they amend the Constitution to get rid of the double jeopardy clause, because you can't appeal an acquittal. His compassion is legendary. He's never been one to let a legal technicality get between him and what he knows is the right result. My friend and co-author, Gordon Mailer, who I just saw walk into the room, there he is back there, tried a multi-defendant case in front of the judge. And when he rested, the main defendant's girlfriend moved for a judgment of acquittal. She was clearly guilty, but she was just as clearly a marginal player involved in the crime only because of her unfortunate love interest in one of the main defendants. Now, a motion for a judgment of acquittal is rarely granted because the law says it can only be granted if no rational juror looking in the evidence in the light most favorable to the government could find the defendant guilty. After hearing argument, Judge Weinstein made exactly that finding. Based on this evidence, he said, no one could rationally find this woman guilty. And he dismissed the charges against her. And then he turned to her. She was seated at the defense table, and he said, "Now, get out of here and don't ever do this again." He can be mischievous. One of my trials before him was United States versus Vic Arena. Little Vic, as he was known, was the boss of the Colombo crime family. And he was a real gentleman, truth be told, but he was a crime boss. And after we convicted him of a bunch of crimes, including murders, he was facing a mandatory sentence of life in prison without the possibility of parole. Exactly 1 week before the sentencing date, Judge Weinstein issued a one-line order putting the defendant on notice that he was considering upwardly departing. Now, when you think about it, there's really only one sentence more severe than life without parole. When we showed up for sentence, the judge said he was thinking about an upward departure in the fine. In the meantime, poor Vic got very little sleep in the MCC. As a colleague, Judge Weinstein is a godsend. He's always available, always has clear, decisive advice. No matter the context, I always have the same reaction to his advice, which is, can we really do that? This should come as no surprise to any of you. This is the judge who just last week told the governor, if you don't schedule a special election by Friday, I will. He writes notes to us frequently. Christina, the woman you mentioned who received that note, had a little taste of what Jack Weinstein's colleagues experience on a regular basis. Handwritten notes on cards that are kind of hard to read, but once you read them, they're perfect. They congratulate, they console, they compliment, whatever the circumstances call for, he nails it. And they always end with, fondly, Jack. He visits our chambers in September to wish us a Happy New Year. Even us Irish kids get that Happy New Year in September. He does it again in late December. He still has an insatiable intellectual curiosity and boundless energy, almost halfway through the 10th decade of his life. No book that's worth reading goes unread. He invites speakers to the courthouse who enlighten us. He travels the world, too many places to mention now, but just to mention a few in the last few years, a couple, Antarctica, Egypt. He just got back from Cuba. He and his staff write and perform a play each year for the entertainment of us all. In the past year, he's taken to writing haikus, which show up in the morning emails. Here's one of my favorites from last September. Ancient judges were ordered to listen. Good idea for modern ones. He's funny, he can make us laugh, and much more importantly, he can laugh at himself. He's generous and he's kind, he's magnetic, he's inspiring. Now, this is a time for reflection for us Eastern District folks. 150 years ago tomorrow, President Abraham Lincoln created our district. And here we are, there's quite a few of us here. We're blessed to enjoy serving on that court with a judge who has spent almost a third of the life of the court on its bench. It's a time for reflection for me, too, because coincidentally, 30 years tomorrow, I started in the Eastern District. I've been working in the courthouse as an AUSA or a judge ever since. More importantly, 20 years ago, I was appointed to fill Jack Weinstein's seat on our bench, the judgeship that was created when he took senior status. You know, and I grew up in an immigrant's household with parents short really on everything, education and money, short on everything but faith and kids, which they both had in abundant supply. And we were better off than most, but my parents were the quintessential little people. So you can imagine how I felt then and how it feels to this day to succeed the judge who, more than any judge in history, looks out for the little people, people just like my parents. Now, you're going to start to hear in a moment about Jack's accomplishments, but here's one that can't be overstated. He has taught his colleagues and the profession as a whole that federal judges, and particularly federal district judges, are uniquely positioned to make real and positive differences, not just in the lives of the people who bring their complaints and disputes before us, although that's hugely important, but in society at large across a broad range of legal and social issues. And he's taught us that it's our responsibility to do everything in our power to make that difference. So, to the annual survey of American law, thank you for honoring our Jack here today. Really doesn't matter what your views are about the wisdom of his decisions or about his conception of the judicial role in our democracy and society. The truth is that no one has ever embodied all of Jack Weinstein's vision, energy, scholarship, creativeness, creativity, kindness, and dedication to delivering justice. He is truly a great American, and his life and career in the law are well worth celebrating, even while they're works in progress still. So thank you, Jack, for being you, and congratulations, and thank you all for listening.
Thank you, Judge Gleason. I'm thrilled now to introduce Elizabeth Cabraser, who's a partner at Leif Cabraser, Hyman & Bernstein. She has served as court-appointed lead, co-lead, or class counsel in over 80 federal multi-district and state-coordinated proceedings. has worked on landmark cases on issues ranging from Exxon Valdez to Holocaust litigation. She has served on the plaintiff's steering committee for the BP oil spill litigation in Louisiana and has represented personal injury and death victims as co-lead counsel for the Toyota sudden acceleration litigation in California. Considering all of that, it's no surprise that Law 360 deemed her the titan of the plaintiff's bar. It's a privilege to share the podium with her tonight. Elizabeth.
Tight-net. There we go. It's a tremendous honor to be here. I'm in awe of the audience, and I can't follow Judge Gleeson, but I can talk about what an inspiration Judge Weinstein has been and continues to be to those of us who labor as lawyers in civil litigation, particularly in what is sometimes called mass tort or aggregate litigation. Not too long ago, somebody asked me what my favorite civil procedure books were. There are a few of us who actually have favorite civil procedure books, and I guess somebody pegged me as one of them. And I came up with 4, my little first aid kit. Of course, the Federal Rules of Civil Procedure, we must have rules. The Manual for Complex Litigation, how to bend those rules in complicated cases. And another book, Lewis Carroll's Alice in Wonderland. It can be read as history. You'll remember the trial, who stole the tarts. That is what happens when someone attempts to conduct a coherent trial before the advent of Weinstein's evidence. It can't be done. It can also be read as a cautionary tale. It's what happens to us in the law when, through pomposity and pretension, we fall into the abyss of absurdity. There is an antidote to Alice, and that's the 4th book. I think it's probably the most dog-eared volume in my little collection, and it's Judge Weinstein's book, Individual Justice in Mass Tort Litigation: The Effect of Class Actions, Consolidations, and Other Multi-Party Devices, written in 1995. It is a slender volume. Its writing is plain, clear, and true, and it both poses a profound paradox in modern litigation and points us to the solution. How do we preserve the dignity and value of individuals in our mass age? How do we counteract the digitization and the depersonalization when people are victimized by mass wrongs? How do we avoid compounding the indignity of depersonalization when we attempt, through aggregations or class actions or mass torts, to bring some measure of fair and efficient justice to a multitude? Judge Weinstein sees the solution in the inherently democratic nature of our litigation system, because it is a reflection of our inherently democratic society, at least by aspiration. We have a representative system of government, and we have representative litigation. The problem for those of us who represent victims, and for those of us who represent the companies that have to make profound decisions about how to respond to wrongdoing or disaster, face this problem every day. It's an ethical obligation and it's an ethical dilemma. And Judge Weinstein has written and written, both in his case decisions, in works like Individual Justice in Mass Tort Litigation, that it is an obligation that endures, it's an obligation that must be met, and that we must pay attention to the individual if the integrity of our legal system is to survive. Fortunately, Judge Weinstein not only writes about the problem and the moral imperative of its solution, he provides an example of solving that problem in pioneering litigation in Agent Orange, in DES, in asbestos, in tobacco, in breast implants. He has sat with victims and explained the case to them. He has traveled the country to make sure that those who could not come to him were able to participate in the process that affected not only their legal rights, but their lives. And he invented Ken Feinberg. The rest is history. When Judge Weinstein wrote Individual Justice in Mass Tort Litigation, it was 1995. And in the years since then, that book, alone of the many works written in those days, has not become obsolete because we still face ever-increasing standardization and globalization. The problem has intensified. Recently, Judge Weinstein wrote a coda to that book, an article in 2012 called The Democratization of Mass Actions in the Internet Age, and that title embodies the solution. If we remember that we are Democrats with a small d, whether we're on the bench or we're at the bar, we can solve the problem of not only delivering justice writ large, but justice that is meaningful to the individual who is submerged within a mass. You have heard anecdotes about how Judge Weinstein treats people, his colleagues, students, clerks, and litigants. And that is the key, nothing more and nothing less than that, I think. To remember that when we are about what we sometimes think of as the lofty and complicated business of the law, sometimes justice is nothing more than giving to each person involved in the system what matters to them, which is what matters to each of us. We want to be heard. We want not to be forgotten. I appeared before Judge Weinstein at the turn of this century in a piece of the tobacco litigation that he was handling. And I went through the tremendous experience of almost, as he reminded me, almost settling tobacco litigation. We were this close, he said. Well, what happened? We lawyers messed it up. I was also fortunate to witness a tour de force of class action jurisprudence, a decision in a case called Simon II, smokers' class action litigation, that was both elegant in simplicity and audacious in scope, the certification of a nationwide class for punitive damages purposes, so that everyone who received compensatory damages in their own individual suits could share equitably in a punitive damages award that fully reflected the wrongdoing, as a jury would find, of the conduct of the tobacco industry without over-deterrence. It was a breathtaking solution to a horrible problem. It endured on the books for 2 years, I think, before it was reversed by the Second Circuit, which took a more conventional view of whether or not Rule 23b1 mandatory class certification could be extended beyond the traditional bounds of a limited fund. Judge Weinstein had written eloquently of the limited punishment theory of punitive damages. That theory, the ideas in that decision did endure, were influential across the country and in decisions of many courts and the thinking of many commentators. Just one example of the ripple effect of Judge Weinstein's writing on the law, on justice, and how to strike that necessary balance, the very balance of the scales of justice between the rights and autonomy of the individual and the need to find mass solutions for mass wrongs in modern society. I've talked about Judge Weinstein's book among the 4 on my little shelf. There was another man who wrote another book in 1963, just 4 years, I think, before President Johnson appointed Judge Weinstein to the bench in Brooklyn. In his 1963 book, Strength to Love, Dr. Martin Luther King observed, social change cannot come overnight, but it causes one to work as if it were a possibility the next morning. Substitute justice for social change and think about Judge Weinstein's deeds, not his words for a moment, but deeds. Since his appointment to the bench in 1967, Judge Weinstein has worked for justice as if it were a possibility the next morning by rising and presiding on a daily basis over his courtroom to dispense justice that day and every day. The daily work of progress towards justice, the daily example of Judge Weinstein, has reinforced Dr. King's admonition to each of us to work as if change were possible the next morning. And that is why Judge Weinstein is the conscience, the voice in our head and in our heart of every lawyer who tries to make a difference in civil litigation today. We fail every day. We fall short, but we keep trying because we have an example. We have an example of a jurist who strives to increase the net store of justice in this country for everyone in this country through whatever procedural and substantive means come to hand, and to whatever extent his boundless energy and ability allow. When justice comes, one morning, I believe it will stop first at a courtroom in Brooklyn. Thank you.
Thank you, Elizabeth. Next is Sam Sakharov, the Bonnie and Richard Reese Professor of Constitutional Law here at NYU. Sam has been a member of the faculty for just about 10 years now, having previously served with great distinction on the law faculties at Columbia and the University of Texas. He is a nationally, indeed internationally renowned scholar and teacher of civil procedure, of constitutional law, comparative constitutional law, the law of the political process, and law of democracy, indeed having virtually invented that last field through the leading casebook in the field co-authored with Professor Pam Carlin of Stanford and our own Rick Pildes here of NYU. In addition to his teaching and scholarship, Sam has served as the reporter for the principles of the law of aggregate litigation for the ALI, among many other roles. It's really an honor to call him a colleague and a pleasure to give him the floor now.
Thank you. I first encountered Jack Weinstein almost 35 years ago. I was in my apartment one night. It was, in fact, the night before my first day of law school. And the assignment for my first class, civil procedure, of my first day of law school was to read an opinion called Hart v. Community School Board number 21. Fine. I sat there, I sat down, opened it. First, it was 240 pages long. So for my students who are here, and you wonder why I don't listen to you when you complain about the amount of reading I assign, think again. 240 pages. I had never read an opinion before. I'm not from a family of lawyers. I didn't know lawyers. 240 pages. And so I sit there hour after hour trying to get through this thing. And frankly, I had no idea what was going on. I knew that there was segregation in New York City schools. I knew it was a desegregation case. That much I could follow. But then I started getting really lost. All of a sudden, there was a discussion about London courts in the 14th century and summoning surgeons to explain whether a wound was fresh or not. And that seemed to be the basis for appointing somebody who's a Columbia Law professor named Curtis Berger as a special master. Okay, I'm sort of following, but I have no idea what a special master is. I don't know who Curtis Berger is. Then I'm reading on, and all of a sudden, Curtis Berger is reorganizing the fare zones and the directions of the New York subways and buses. And I couldn't believe it. I'd grown up largely in New York, and who is this Curtis Berger? But that's not what really bothered me. I turned back to the first page of the opinion to see who had written this, and I see Jack Weinstein. And I thought to myself, who the hell is this guy, Jack Weinstein? Well, nearly 35 years later, I am well aware that I was neither the first nor the last person to ask that question. Who the hell is this guy? Well, so here's a little bit about him through my experiences with Jack. I got to know him when I moved to New York to join the Columbia faculty. And I came to Columbia to fill out a tradition in civil procedure that I think, in all fairness, Jack Weinstein embodied. It was a great tradition. It had a few open positions. They were looking, and I filled it. And if you think back on what he created, you see part of the influence. So here are some of the junior folks that he brought on as his personal fellows that then went on to more or less success in the law. And by the time I got there in the late 1990s, they had all moved on. And so there was a need for people like me. So one of them was a guy who'd gone up and finally ended up teaching up at Harvard, Arthur Miller. Another one was a woman who did reasonably well but had left teaching altogether, moved to DC and had some position, I think, on the Supreme Court or something like that. And these were Jack's proteges. These are the people that he picked out and brought into the law. And it was a great source of honor to me that he treated me as if perhaps I might belong in this tradition. I never got quite the okay that I did from Jack, and I think the reason was that some years later I left Columbia to come here. And that provoked my first distinct moment of irritation that I saw of Jack with me. And he let it be known quite clearly that he did not approve of this. And I think I might still be in the doghouse on this one, but I'm not, maybe he has forgiven me this. I want to give an example of the place where I had the most contact. I've been in the classroom with Jack. I've appeared in his court. I've been on panels with him for the MDL gathering of judges, and I've been in many circumstances with him. But the experience that is strongest in my mind is the role I had when I was a reporter for the Aggregate Litigation Project that Trevor mentioned. Part of the ALI process is that they don't want to give the good name of the ALI over to people like me, so that they appoint minders. They appoint people who have to say, yes, you're doing okay, and if not, they can collectively fire you. And the minders I had included Ken Feinberg, included Elizabeth Cabraser, included Arthur Miller, and of course, it included Jack Weinstein. Because this is the area of law that Jack has shaped probably as no other judge has in the United States. If you think back to asbestos, you go back to Agent Orange, you go back to the liability of gun manufacturers, of pharmaceutical manufacturers, in each of these circumstances, Jack is way out ahead of the law, way out, and pushing the law. Now, to be fair, many of these decisions were overturned by the Second Circuit. In fact, most of them were. In fact, who cares? Because he just kept doing it and got overturned again and kept doing it and got overturned again. But each time it got overturned, the law moved. The law moved. The circuit didn't look like it did before. It was an educational, interactive process. Somebody had to push. So we started this project to try to bring some conceptual order to the world of mass litigation. And this has turned out to be a hard project because this is a messy area. There's a lot of informality that goes on. You litigate for a while, then you turn it all over to Ken to do whatever it is that Ken does, and somehow it gets resolved. But there aren't a good set of principles that guide us through this, and we were trying to do this. And there was skepticism. The betting line was that we would never produce anything because there are such sharp divisions in this area of law. But among all the advisors that I had in this process, there was no sharper critic of the work that I produced than Jack. Jack thought from day one that I was underselling the capacity of the project. And it was a fight over a many-year period to see whether I could produce something that was worthwhile in his eyes. And let me explain why, because it's a fundamental issue about the conception of law. We were trying to work out how courts deal with the cases that are before them, the cases that are challenging but can be handled in some sense. Jack's view was that this was the wrong set of questions. The right set of questions is how do we recapture and restore the concept of equity, which had driven the courts outside of the narrow domain of common law disputes, outside the narrow domain of what is known in the positive law, the statutory law, the edicts of Parliament. And Jack's view was that when you get into mass society, the concept of equity had to drive not just across the procedural domain, but in the areas of the evidentiary rules. How do you use epidemiological evidence? What does it mean to say somebody had an adverse effect from a drug when only you can show that there was this greater than not likelihood that it's correlated with drug exposure? All these kinds of questions, the evidence, and then he wanted us to go after the substantive law of what it is to be wrongfully exposed to a potential hazard. Right? That's an amazing set of issues. That's the hardest issues. And he pushed on that. And I'll conclude with a story about one of the last meetings we had with the advisors of the ALI. We were wrapping up the project. We were in Philadelphia. And for the reporter, for me, it's a very difficult process. You have to go through several days of all-day meetings. People are yelling at you, and it's contentious at various points. And on the last day, Jack and I were having breakfast. And Jack said, you know, I talk too much. I don't listen enough. I think today I'm going to sit and just be quiet and listen. And I thought, yeah, and maybe the sun won't set. But okay, we get into the meeting room. Jack sits front center as he always does. As soon as I start to speak, maybe before I start to speak, hand right in front of you. You can't miss him. He's a big man. You can't miss the hand in front of you. And he said, I don't think you're addressing the right set of issues here. I said, okay, here we go again. And we spend the day on it, and he's pushing. And it's an incredible thing to be pushed this way because it's an intellectual force that's coming after you. It's not personal. It's not vindictive. It's powerful. And we spent the day, we got through the whole thing. And then that evening, we took the train together back to New York. And so we're sitting on the train, and Jack says to me, I have a few more thoughts. He said, but you're tired. You probably want to take a nap. And I thought, I'm not going to be put down for a nap by a man more than 30 years my senior. This is not going to happen. And then we talked for an hour about how far the law can push and what one needed to do. And I realized 3 things in that conversation. First, I really was tired and wanted to take a nap. He was absolutely right about that. I was exhausted, but I wasn't going to. Second, I realized just how coherent his idea of what equity and justice were, how it was. There was something that animated it that had a holistic vision that's just incredible. This is someone who's spent decades on a district court bench, right? So he's dealt with day in, day out, the minutia of the administration of the law, the criminal sentences, all the rest. And there was this animating, driving passion that stood behind it that made all of this make sense. And the third thing I realized, and sitting there on the train as I was listening to Jack, was it had taken me a quarter century, and I wasn't so proud of how long it had taken. But finally, I thought, I think I finally understand Hart versus Community School Board number 1. Thank you.
Thanks, Sam. You know, it happens once in a while that Columbia faculty end up at NYU, but I think it's going to be okay. Now I'm really pleased to introduce Les Fagan, a senior partner in the litigation department and member of the management committee at Paul Weiss, Rifkin, Wharton, and Garrison. He has 30 years of experience in handling complex civil litigation matters for a range of clients. He's the author of numerous publications on arbitration, intellectual property, and products liability, among other areas. He's known by the American Lawyer as one of the lifesavers for his work on behalf of A.C. Nielsen and Company, and his skill has been recognized in numerous publications, including Best Lawyers in America and Legal 500. In addition to his work at Paul Weiss, Les is a director of the Lawyers Committee for Civil Rights Under Law and is on the board of the International Rule of Law Project. He also serves as a lecturer at Columbia. He earned his JD from Columbia, and after that went on to clerk for Judge Weinstein, and we're really thrilled that he's here with us tonight. Les.
Thank you, Trevor, for that very kind introduction, and thank you, Christina, and the annual survey for involving me in this wonderful event tonight. You know, I was sitting here and listening to all these speeches, these wonderful, eloquent tributes to Judge Weinstein, and I was saying, wow, what a fabulous, unimaginable opportunity it would be to be Judge Weinstein's law clerk. And I said, wait a minute, I was Judge Weinstein's law clerk. That's true. I clerked for Judge Weinstein approximately 40 years ago. And Judge, it's occurred to me that I've never really thanked you. All right, I'm a little slow in expressing gratitude, but it was a fascinating and wonderful experience, and while over the last 4 decades, which have not been entirely uneventful, I don't think I've ever had a legal experience quite as exhilarating as helping you to render justice. So thank you, Judge. It's a little late, but never too late. I just want to say that I have one grievance against the judge. You know, when I got out of Columbia Law School, I was 24 years old. The judge was more than 30 years my senior, already a famous jurist. Now, when you're 24 years old, you have this expectation that you're going to age in step with your friends and colleagues, particularly your elders. We all know that one of the few compensations of aging is that you can look at your older friends and say how much worse they look than you. Judge Weinstein has totally deprived me of this compensation. He has steadfastly declined to age. So while my joints have begun to creak, while I can enter a room and not quite remember why I entered it, I'm a little worried about this room tonight, Judge Weinstein has not changed at all. He looks the same. He looks terrific. He works the same. He thinks the same. It is really annoying, but I'm delighted about it. Judge Weinstein may be one of the most honored judges in America. He has honorary degrees from Yale and Columbia. He is the recipient of innumerable awards, the Edward J. Devitt Award, the Harvard Law Medal of Freedom, the Columbia Alumni Medal, the Lawrence Wien Award for Social Responsibility. There have been countless law review articles which have analyzed Judge Weinstein's countless law review articles and his opinions. A rather enthusiastic commentator from Academe has said, and I quote, "Jack Weinstein is a man of vast imagination and almost blinding brilliance, as uncomfortable with traditional formulations as any individual of genius in any field is." Yikes. And of course, there's today's wonderful event tonight and the speeches you've heard. The judge accepts these plaudits and these honors with humility and gratitude, and I suspect a little bit of bemusement because the son of Lou and Bessie Weinstein from those old days in Bensonhurst, the son who delivered milk from a milk wagon for $1 and 1 quart of milk a day, has come so far and achieved such great and utterly deserved recognition. But at the same time, as some of the speakers have already suggested, the judge has generated a bit of criticism. Some of it has even come from the Second Circuit, which I have to acknowledge has reversed the judge just a couple of times. I am told that one Fifth Circuit judge has said privately, Judge Weinstein doesn't think he's a judge. He doesn't even think he's a congressman. He thinks he's the whole damn Congress. He has the distinction of having been condemned by both the TV personality Dr. Phil and the late FBI director J. Edgar Hoover. And the bar has not been silent. I remember vividly sitting in his courtroom some years back, and upon the judge's entrance into the courtroom, a plaintiff's lawyer leaned over and whispered in my ear, "There, but for the grace of God, goes God." Why does Jack Weinstein generate such differences of view, such controversy? There are, I'm sure, many, many reasons, but I submit there's one primary reason. He has honestly and loudly expressed the view that a judge not only has the power, but the moral obligation to interpret and apply the law expansively to reach the just result. Now, many judges proclaim themselves to be strict constructionists and disavow the duty to do justice through equity. Some judges kind of get to the right result through discretion, but covertly, and sometimes in silence. In contrast, Judge Weinstein has said over and over again that a judge is, and I quote, "required to exercise discretion and assume responsibility for decisions that require hard thought and balancing of alternatives rather than applications of rigid and simple rules." He has written, "The duty to decide cases in accordance with statutes, precedent, or regulations cannot be absolute." And accordingly, in his judicial career, the judge has used his moral vision, his creativity, yes, his genius, all within the breathing space of the law to render justice. Now, all this makes some people uncomfortable, but it is a necessity. It is a moral necessity. Now, statements recognizing this moral imperative in doing your job are plentiful. My favorite is in Shakespeare's Henry V, when the king, in disguise, debated essentially this question with a group of his soldiers on the eve of the bloody Battle of Agincourt. One soldier argues with the king, not knowing he's the king. He says, "We know enough if we know we are the king's subjects. If his cause be wrong, our obedience to the king wipes the crime of it out of us." Surprisingly, the king says, "Not so. Every subject's duty is the king's, but every subject's soul's his own." So, undeterred by controversy, Jack Weinstein goes on with the job of judging. He follows the law, but when he finds that the rigidity of the law is inadequate to do justice, he follows his soul to interpret, apply, shape the law, and sometimes, infrequently, even to defy it. It's not hidden, his philosophy. He has explicitly and repeatedly stated. In this way, and in so much of what he's done, yeah, he is our conscience. So, at a law clerk's party for his 90th birthday a little while back, the judge ended his remarks with a commitment to future service just by saying these simple words: "There is much work to be done." A few people in the audience wondered at this point, why doesn't the judge take some more time to relax? One woman at my table said, she even suggested, maybe the judge should buy a condo in Florida. Could you imagine Jack Weinstein playing shuffleboard? I don't think so. Those people did not understand. He is in the courthouse every working day. He presides over trials, motions, and settlements. The opinions and the articles keep coming. For him, it is all about rendering justice no matter what. That is surely our most noble impulse. The toil for justice, the battle for justice, the pursuit of justice, to the disdain of popularity or consensus. You see, he can't stop. Great men of principle seldom do. Congratulations, Judge.
Thank you, Les. I'm now pleased to introduce Diane Zimmerman, our Samuel Tilden Professor of Law Emerita here at NYU, and another former clerk to Judge Weinstein. She's an expert on freedom of speech and press, as well as intellectual property. She has served, in addition to her role here at the law school, she's been the lead distinguished visiting professor of constitutional law at William & Mary, the inaugural Hosier Distinguished Visiting Intellectual Property Scholar at DePaul College of Law, and a fellow at the London School of Economics. She's also served as a trustee of the Copyright Society and as a court-appointed reporter for the Second Circuit's task force on gender, racial, and ethnic fairness, in addition to chairing the ABA First Amendment Rights Committee and the New York Bar Association's Civil Rights Committee. We're thrilled to have Diane here today.
Thank you, Trevor. Thank you, Christine. And most of all, Judge, thank you. I know that there have been a lot of comments made about the multiple contributions that Judge Weinstein has made to the law. My account is going to be rather more personal, partly because I was afraid that I would end up repeating everything that everybody else had said. I've been a lawyer now for more years than I intend to reveal to anyone here, but one of those years stands out above all the rest, and that was the year that I clerked for Judge Weinstein. The common wisdom when I was a law student at Columbia was clerk for a circuit court judge. But I didn't want to clerk for a circuit court judge. I had a hero. I had a wise man. I had a role model. I wanted to clerk for Jack Weinstein. And I never felt more pleased and honored than the day that he said that he would invite me to be his clerk, and then spent about, I'd say 15 minutes trying to discourage me from saying yes. The typical Jack Weinstein maneuver. What I quickly came to realize after the clerkship started was that Judge Weinstein didn't need law clerks. In fact, I think we actually took up more of his time than we contributed to what went on in the courtroom. But he was a teacher, and he loved having new subjects to work on, and he hoped that he could steer all of us into academia. He actually succeeded in an enormous number of cases, including both with me and with my fellow law clerk. But in the course of that year, in addition to being steered, I learned a great number of very important things. The first thing I learned, which is a good lesson, was humility. And boy, did I learn that. If Judge Weinstein had been in charge of General Motors, there would never have needed to be a federal bailout. He was able to run that docket in that courtroom with such stunning efficiency that there was no justice that ever got delayed. And he would actually multitask. He's the only person I've ever known who could really do it. He would sit at the bench paying meticulous attention to what was going on in the courtroom before him, at the same time that he would be editing a law review article or a speech. I've never seen anything like it. And furthermore, he was really, I think, disappointed profoundly in the fact that I couldn't do it. It was quite horrifying to realize that I had failed so early in my career. But on the positive side, what I learned was what a first-rate judicial system could look like in action. Above all, it's one that strives for fairness and for accessibility. In Judge Weinstein's world, what we strive for is to serve the public. Not judges rule their domains, not as kings, although there's some similarity, I might add, but really as servants of the public. As he once wrote, a judge should expose himself or herself on a person-to-person basis to the emotional needs and other needs of litigants. Hence his well-known eschewing of robes during accepted trial, his pioneering attempt to give pro bono litigants in civil cases access to counsel. And as a subsequent clerk revealed, his well-placed pressure now and then on people in his chambers to give up a suit or a shirt or two so that a pro se litigant wouldn't have to appear in court in a way that would make that individual feel out of place. He wanted people to experience the courthouse as a place where they were welcome. And it was so to successive waves, not only of litigants, but of the school kids who were regular appearings in the courtroom. They loved being there, and you could tell it. He hated metal detectors, even when they were necessary. He would rail against them. And his chamber's door was always open, which I have to say led to a few surprising visitors, and not always ones that made me personally feel terribly comfortable, but we can go into that some other time. Finally, the judge opened my eyes to understanding the operation of the law in the social context, rather than solely in a formalistic vacuum. He knew that ignoring the broader consequences of discrete legal decisions can be perilous, that society is poorer for every instance where law and justice diverge, and that the best way to deal with problems with no obvious ideal solution is not to walk away from them, but instead to evaluate what's at stake and to apply a bit of well-known Weinstein common sense to craft a sensible compromise. He taught me that law should have a heart, not just a head. Having learned all this and having moved on to a happy career of my own, I must confess that I never stopped holding the judge in considerable degree of awe. I was afraid that I might not live up to his expectations of his law clerks. You can imagine, therefore, that when he and I were invited to co-teach the Law and Society seminar at the Aspen Institute one summer, that I was more than a little nervous about sharing the podium with him. And to make matters worse, I got a phone call shortly before we were supposed to go, telling me that I was to call him Jack, that we could not go to Aspen and teach together as the judge and Diane. This was not going to work in his view. So I practiced. I really did practice. I tried, but it was sort of as if my rather formal father had suddenly declared that I should call him Adrian instead of Dad. It was just very hard for me to do it. So when I arrived at Aspen and realized that he was really serious about this, it was quite a chilling experience. Every time I would open my mouth to address him, I say him, you'll see why, he would look at me, and if he thought I was about to lapse, one of those eyebrows, those famous eyebrows, would sort of go up a little bit, and I would sort of stumble out, "Jack." Well, even now that both of us, Judge, are old enough for Social Security, the truth of the matter is that I still call you Judge in my heart of hearts, and I think that's what you're always going to be. Joack is the best I can do, and it really takes an awful lot of work to remember to do it. Thank you for everything.
Thanks, Diane. And our final dedicator this evening is Ken Feinberg, founder and managing partner at Feinberg Rosen. Ken, well known to all of us here, I'm sure, is a leader in mediation and alternative dispute resolution and has been responsible for resolving many of the most high-profile and complicated and vexing disputes in this country's history. He served as a special master of the federal September 11th Victim Compensation Fund and as fund administrator for the Hokie Spirit Memorial Fund following the tragedies at Virginia Tech, among many others. In 2004, he was named Lawyer of the Year by the National Law Journal. He's been named repeatedly by publications as one of the 100 most influential lawyers in America. I've seen him recently referred to as the Master of Disaster. We are proud to count Ken as a graduate of NYU Law School and as an adjunct professor here, and I'm very pleased to give him the podium.
I want to thank the Dean and Christina and the staff of the survey for being part of this. Now look, the hour is very late, and there's been a lot said about Judge Weinstein, and I'm last. So I can be relatively brief, so we can get on to the reception, because everybody has said just about everything there is to say about Judge Weinstein. But I want to start off my comments by just reading to you 3 brilliant paragraphs that best describe the career and success of Judge Weinstein. No oral presentation can rival the strength and eloquence of these 3 paragraphs. So just bear with me, they're very short, but it says what there is to say about this great judge. Quote, a law professor at Columbia, Weinstein has written hundreds of law review articles, speeches, essays, commentaries on virtually every aspect of modern domestic and international law. Weinstein is still a nationally recognized legal scholar, author of definitive textbooks, legal treatises on evidence and civil procedure. His work is often cited by U.S. Supreme Court justices in the same opinion, both majority and dissents, in reinforcing the credibility and persuasiveness of their respective legal arguments. One Harvard Law School professor commented that Judge Weinstein was, quote, the most important federal judge in the last quarter century. And that was in 1981. Weinstein uses his bully pulpit as a federal district judge to write a cascade of legal opinions on every conceivable subject. Whatever the definition of judicial activism, he is the best, most convincing example. Undeterred by appellate court reversals of some of his most creative judicial opinions, Weinstein, still a federal judge in his 90s, offers almost daily legal commentary that, in its force and careful legal analysis, is more convincing than anything written by the Court of Appeals. Weinstein became a valuable advisor to Senator Edward Kennedy, advancing effective arguments on almost an unlimited range of federal and state law policy initiatives. On one issue after another, Senator Kennedy would say, quote, "Find out what Jack thinks," unquote. In all important matters, both professional and personal, no one would dream of making a key decision without first checking with Judge Weinstein. It is not only his legal and political skills, but more important, it is his judgment, his worldview on all issues, big and small, that lead everybody to his doorstep. In these countless other personal and professional matters, we look first to Judge Weinstein for advice, guidance, and friendship, unquote. Now, you can't beat that. And if you want to read the rest of what that book says about Judge Weinstein, you're going to have to get my book. Now, my book, Who Gets What? Fair Compensation After Tragedy and Financial Upheaval, Public Affairs Press, 2012. Now, you may have trouble finding this book today. Don't worry. Don't worry. My personal supply of this book is virtually inexhaustible. And if anybody has trouble, we'll get you a copy. I just want to add 1 minute of comment about the judge. Elizabeth said, quote, "Judge Weinstein invented Ken Feinberg," unquote. That statement is absolutely true. If not for Agent Orange, when the judge just picked me just called me up and said, "I want you to mediate this case." Judge, I never took a course in mediation in my life. There isn't a mediation course in 1984 at NYU. Doesn't matter. You're perfect for this. You're perfect. Overnight, that one case, changed my life, my professional life. And Judge Weinstein did invent Ken Feinberg. So that's just to clarify the record on that. Judge Weinstein taught me over the last 40 years 3 overriding principles of great importance to the people in this room, but particularly of importance to the students and the staff of the annual survey. First, don't plan too far ahead. Life has a way of changing the best laid plans. Believe me, I know. If those planes hadn't hit the World Trade Center and the Pentagon, if that oil rig hadn't exploded in the Gulf of Mexico, if those poor Boston Marathon runners weren't the victims of bombings, if some deranged student gunman at Virginia Tech hadn't slaughtered 32 people, my professional life would be very, very different. Law students who worry about their resume, especially at NYU, don't worry so much about your resume. Judge Weinstein taught me live professionally today to get satisfaction. Life has a way of changing the best laid plans. That's point number 1. Point number 2, he taught me what it really means, the phrase, the communitarian ethic. He's written about this. But the communitarian ethic, we all have an obligation to give back to the community in countless ways. But it's very, very important that what you do, no matter what strain of work, no matter what your profession might be, no matter what line of legal career you enter, the communitarian ethic. We are one community, and give back to the community that is such an essential part of civilization and the way we live in this country. And finally, a very important lesson from Judge Weinstein, which for me was reinforced every day by Senator Ted Kennedy, a pretty good friend of Judge Weinstein. And it was this: every individual can make a difference. No matter what you do, no matter what your role in society with family and jobs and profession, every individual can make a difference. Senator Kennedy lived that way. Judge Weinstein has lived that way. We've heard about how Judge Weinstein implements that axiom every day in his courtroom. Every individual can make a difference. And no matter what you're doing in law school or when you graduate law school, remember that what you're doing interstitially, everybody together, builds a community. And not only builds a community, but builds a life. My life has changed dramatically because of Judge Weinstein, and it's an honor and a privilege. And the book is available. We'll talk about it. It's an honor and a privilege. Thank you, Judge.
Thank you, Ken. Ken is our final dedicator tonight, but of course not the final speaker. As much as we loved hearing all of these, we can't have an evening honoring and celebrating Judge Weinstein without learning more from him. And so we look forward to his address in a moment. But first, Christina is going to present him with our award. Yes?
Yes.
Okay. Judge, what do we do right here?
Judge Weinstein, on behalf of the NYU Annual Survey of American Law, we'd like to formally dedicate our 72nd volume to you in honor of your contributions to American law.
Well, thank you, Dean. While I was listening to all this, I was within me trying to keep down that kid delivering milk in Bensonhurst and kind of saying to him, "Shut up. Don't really tell the rest of it. Don't tell the other side." This is a wonderful, wonderful gift. And of course, the crystal gavel that is the physical element of the gift is one that I will be able to use without fear of breaking it. Because I've never used a gavel once in my career as a judge. So it's safe. And my dear friends and colleagues, for your presence here today, I'm truly grateful and overwhelmed. And thank you, Editor-in-Chief Lou. Where are you? Thank you. And your staff for arranging today's events. This dedication by the NYU Annual Survey of American Law is dear to me. It's particularly gratifying to receive an award from New York University Law School because I owe so much to this great institution. One of your distinguished alumni, Judge Eddie Weinfeld, was a trusted advisor. I've had fun working with so many NYU law clerks. The distinguished writings of NYU faculty, such as Arthur Miller, that I relied on just a few weeks ago in deciding an issue of foreign law as fact or law, and his scholarship. Bert Newborn, whose new book on Madison I quoted just last Friday in a voting case. And Sam, your American Law Institute book on aggregate litigation is essential in our work in the courts on mass torts. And as for you, Diane Zimmerman, you're one of my first law clerks. You taught me how to be a judge, how to act like a judge, and at a critical moment in one of my speeches, you taught me how to pronounce epidemiology, which had me floored for a few minutes. I am also grateful to you, Elizabeth, because you shattered the glass ceiling in precedent-setting litigations and in your leadership in the field. And there is no difference in gender now, I think, in that aspect of the profession and in the profession generally, largely due to your kind of extraordinary work. Judge John Gleeson has led the nation in rationalizing sentencing, and at the same time, quietly, he's revolutionized credit card practice with multi-billion-dollar class actions. Les was another stellar law clerk who worked to teach me how to decide cases and write opinions. He's now a leading litigator at Paul, Weiss, Rifkin, Wharton, and Garrison, and I must say I admire him mostly because he is legal advisor to Judge Judy. Who he has made a very wealthy woman. And of course, I'm so pleased that so many of my Eastern District colleagues are here. This dedication is accepted on behalf of all of our federal judges. It's not a dedication to me alone, but it's a dedication to federal district judges. And it's been an honor to serve alongside this devoted and courageous band for almost 50 years. My admiration for them continues to grow. Trial judges are the eyes and ears of the judicial system, applying the law to the real world. Our grasp of the facts and societal changes are essential, not only in deciding individual cases, but in providing the basis for needed changes in the law, both procedural and substantive. Bringing the world to the courthouse and the courthouse to the world is our job as trial judges. In my lifetime, this nation has taken huge steps for equal rights. It's protected against many forms of discrimination. It's defended workers' rights. It's ensured equal voting and enforced the Bill of Rights. And federal judges have been vigorously enforcing these laws ever since World War II. We as judges have the necessary procedural discretion under the broad principles of the federal rules of civil procedure, criminal procedure, and evidence to ascertain the truth. This is what Rule 1 of the Civil Rules tells us. And to secure the just and the swift determination of each case. That is what the rules tell us. And when seeking truth, passivity is not a virtue. Justice requires us to be skeptical, to doubt, to question, to test, and to think outside the box. That we may be reversed on appeal must not inhibit us in the least, and does not. A famous example is don't ask, don't tell. You remember that just a few years ago. It was ruled unconstitutional by Judge Jean Nickerson, but reversed on appeal. And then the people, the legislature, and the president agreed that Jean was right. And they changed the law to what he said it had to be, and what we who have been observing what has been going on in society knew it would be. When thinking about my role as a judge, I often return to one of the law's greats. Leo Glasser often points me there, of our court. Justice Cardozo, once himself a trial judge in 1928, put the essence of the judge's challenge this way. Without a full and rich background, I'm quoting, of knowledge and culture in fields foreign to the law itself, we shall never reach the perception of the problems to be solved. The concept of the continuity of knowledge is teaching us day by day the need for an enriched equipment and is pointing the path to be followed by the judge of tomorrow. When Cardozo spoke of the need for enriched equipment, almost a century ago, he could not have imagined the kind of technological help we can now get. We now gather and quickly process information from huge databases. Statistics provide insight. Virtual reality machines help recreate events. And parties in trials far from the courthouse participate and can participate more effectively in video conferencing and through other devices. But there are dangers in relying on modern technology. Discovery with massive amounts of documents is challenging. Statistics can be misleading. Virtual reality may seem so real as to trick us into relying on misleading opinion, or hearsay, or lies. Bringing masses of potential parties into the courtroom may complicate reaching a settlement. All of this modernity cannot supplant the need for the bar and the bench's wisdom, empathy, and critical analysis. Ultimately, our legal system depends upon the good sense of counsel and judges. And fortunately, we can depend upon great law schools like NYU's to train the women and the men who will provide justice in this great nation in the years ahead. Thank you for tonight.
Judge Weinstein, thank you for that uplifting set of remarks. I want also to thank each of our dedicators who joined us here this evening. Thank you for your remarks as well. Thanks also to Christina and her colleagues at the annual survey. You've done a terrific job and you made an outstanding choice this year. And finally, thanks to all of you for joining us for what I hope you'll agree has been a really terrific evening. And I hope you'll now join us for a reception here at this end of the room. Good night.